is still your favorite legal program, Jurisprudential Tuesday. This program is brought to you by the Faculty of Law, University of UUTH. This program aims to educate, inform, analyze, and address issues from the legal perspective. I am Odinaka Chukwuzoma Ihianacho, your host. On today's edition, we will be taking a look at gunshot victims and the law in Nigeria. But before then, on September 26th, a lady by name Greatness Olurofemi was stabbed and pushed out of a moving vehicle in Abuja, and she was rushed to a hospital, a very popular one at that, and she was refused treatment unless a police report was provided, as she bled to death. With this incident, civil society groups like Yali Network had petitioned the Minister of Federal Capital Territory and the IGP. On the 25th of October 2023, a directive was given by the IGP, Olukayode Igbetokun, via an internal memo dated 25th October 2023 and signed by the Police Principal Staff Officer Olatujin, directed hospitals to henceforth treat gunshot wounds without insisting on a police report first. And this, he said, is in compliance with the provisions of the Compulsory Treatment and Care for Victims of Gunshots Act 2017. Joining us to shed more light on this discussion are two erudite lecturers. The first is Professor Idorenyin, and she is an Associate Professor of Law, Head of Department Public Law. She is an attorney, a human rights activist, a negotiator, a poet, a researcher, and an alumnus of Harvard Law School network of universities in legal aid institution. The second guest is Dr. Timothy Nottidge. Dr. Timothy Nottidge is an associate professor and honorable chief consultant in orthopedics and traumatology, and the current head of that department, with about 19 years of experience as a specialist. His specialty is in trauma patient care advocacy, and in this regard, he innovated the UUTH Trauma Registry and has published the only paper on gunshot injury in Akwa Ibom State on Google so far, in addition to many other papers. He has also been a Deputy Chief Medical Director and the AG Dean of Faculty of Clinical Sciences. It's good to have you, Associate Professor Idorenyin and Associate Professor Timothy Nottidge.
Thank you. Hello, viewers. Good to be here.
Just like I said, today is going to be a roundtable discussion because you're looking at a very critical issue. So let's start with the gentleman first, Associate Professor Timothy Nottidge. Who is a gunshot victim?
Hello, viewers. Thanks very much for that question. From our perspective as healthcare professionals who treat patients that have suffered these injuries, we consider gunshot victims to be people who have gunshot wounds. And these are wounds in which the projectile was emitted by a firearm and impacted on the person's, obviously a living person's tissues, resulting in a gunshot wound. And there are many properties of these wounds that determine the severity of the injury to the patient, as it were, assuming he or she has been brought to a healthcare facility. Some of these would include the velocity of the projectile on impacting the patient.
And Dr. Timothy, thank you so much. Associate Prof. ID, there would be a legal perspective to this definition of a gunshot victim.
There's a law that actually also defines who is a victim of gunshot wounds, and that's the law that we call the Compulsory Treatment and Care of Victims of Gunshots. That law came into existence in 2017. Section 15 of that law particularly says that a victim of gunshot wound is anybody who has suffered from gunshots fired from what may be termed as firearms or resultant effects or gunpowder, or any projectile that can be defined as a firearm. And I also agree with Dr. Timothy that there are several velocities. There are various degrees of velocities of how a victim of gunshot wound suffers. So generally, in local parlance too, anybody that has been shot by gun or what may be termed as firearm is a victim of gunshot.
So now we bring it to Nigeria. Are there laws that are regulating the gunshot victim, or treatment rather, of a gunshot victim?
Well, the truth is that, let's start with the grown norm of Nigeria. That's the Constitution of the Federal Republic of Nigeria, 1999, as amended. If you go to chapter 4, you go down to section 33, it clearly states, without any equivocation, that every person is entitled to the right to life, and that the life of a person can only be taken away where a court of competent jurisdiction has found such a person to be liable for what we may call capital offenses, for which the law prescribes that
Capital offense. Let our viewers understand the capital.
Okay, let me just finish that. What section 33 says, that every person has a right to life, and that the life of the person should not be truncated or deprived of, except in circumstances where a court of competent jurisdiction has given an order or a judgment terminating that life by way of a death penalty. And death penalties are usually given in cases that with the law terms to be capital offenses. Such cases include armed robbery, murder, etc. So for linking it up with the question you are asking, for persons who rob and make others have gunshot wounds, such persons are generally termed to be armed robbers, and that's a capital offense. And then, of course, you also have the right to, like I said, right to life. That's the ground law from our constitution. And then, certainly, we also are under the act that we are analyzing right now, that particularly states in section 1, if you read down to section 1, section 2, section 3, it clearly states that every healthcare provider, every hospital, every medical center is under the non-derogable obligation to treat victims of gunshots without police reports or without an initial deposit.
So, Prof, are you saying that before now, you need a police report to treat a gunshot victim?
Yes, by the Anti-Robbery and Firearms Act of 1989. Clearly, that was an act, that was a law that came into existence because of the rampant occurrence of armed robbery. There was a need for the military government then to have that Anti-Robbery and Firearms Act in 1989, which clearly made it an offense for anybody to harbor or give to quarter or render assistance to any person or group of persons that have been involved in armed robbery. And that brought the fear, the reluctance, the total zero assistance of persons, healthcare providers, hospitals, and more often than not police to persons who may have gunshot wounds, because there was this general view that if a person has gunshot wounds, you may probably be a member of an armed robbery gang. And therefore, nobody wanted to be caught within that legal requirement or rather, legal disallowment to render help. So healthcare providers and hospitals shied away and totally refused to help people that had gunshot wounds. But I thank God that we now have the law that clearly makes it obligatory. And it is a law that is of international standard, because, I mean, if a man doesn't have a right to life, if a man doesn't have life, he can't enjoy every other human right.
Assistant Prof, let me stay with you.
Okay, sorry. I also wanted to see.
Treatment and care of gunshot victims are there any other?
Yes, I also want to talk about Section 20 of the National Health Act. It clearly also states that every healthcare provider, hospital, medical center has the obligation to render qualitative health care services to every patient that walks into their organization to the best of their ability, of course. That ability is not subjective, it's objective.
It's indeed objective.
Yeah.
Dr. Nottidge, this law was signed into law 2017 by the then President Muhammadu Buhari. And what's the level of compliance since this act was signed?
It would surprise me that listening to my colleague, it appears there's an impression that all health professionals were rejecting such patients. So it would surprise you that when I was doing residency training at University College Hospital, Ibadan, started in 1998, we were not rejecting gunshot victims.
Well, that's good to hear.
It never occurred to us to reject gunshot victims. I treated cult victim of cult violence, who was shot in his neck and almost died. We battled, if I will use that common term but misapplied, to save him for about 48 hours. And eventually, the young man was discharged.
But was there any police report given?
Frankly, we did not use that as a determinant for anything that we did for the patient. We allowed the staff in the emergency department to sort that out while we just took care of the patient. So I can't even answer the question. So in a sense, we were disobeying the law in force at that time because our primary concern was the patient. We simply treated them as victims of injury and went on with care. And this is, how many years ago? 1998? That's about 25 years ago. So this new law in 2017 is long past due. Now, the problem I quickly see, because I need to bring this up, since listening to my colleague, I've learned a lot, is that in a bid to correct an unnecessary patient-unfriendly initial law, the second law now went far overboard, unintentionally placing gunshots above the priority of care for all the other patients of trauma and injury that we see every day. There is no reason I see why that should apply only to gunshot wounds. Why not apply to all victims of injury who are obviously in a situation for which they did not plan? Road traffic injuries are far more common than gunshot injuries. In the study I did in this state some years ago, in 22 months, we got 27 patients of gunshot injury. And my colleague, Omagbemi, did a similar study in Delta State, and in a year or so, got 47 victims of gunshot injury. In that same period, here in UUYO, we had over 1,000 patients who had injuries from other causes, mostly road traffic injuries. What happens to them?
You know, doctor, when we talk about gunshot victims, so that the number is not much, but the fact is that they are not actually attended to. I mentioned the case of Greatness in Abuja. She went to a hospital. She was rushed into a hospital, but they refused to attend. So we are not looking at it from the perspective that it is greater in number, but they're looking at it from the perspective of they've been attended to and treated on time.
Unfortunately, even that information falls into the loophole of sporadic cases. In our own teaching hospital here in UUYO, which I thought you would have checked, there's no such experience. I came to start work there in 2005, and since I came, as far as I know, because I brought the practice I was used to, we treat them as patients of injury, along with the other patients we treat, and we let the administrative groups fill some of those police incident forms, as they call them. I've hardly ever had to fill those forms. My primary concern is the patient. See what I mean? So if there are sporadic cases of people acting on a law that actually was, if I use the word promulgated, I'm a layman in law, don't mind. I think it's more a matter of education and facilitation than victimization, because they're not acting without a basis for that action. If there are still sporadic cases where this occurs, so that we don't.
Hold your thoughts on the facilitation and the training of that. We'll still come back to it. Let me go back to Associate Prof. Idorenyin. Are there rights of gunshot victims? Because just like Doctor has said, he has not experienced such things. So what of those people that experience it? What are the rights of these victims?
Okay, well, the court held in the case of COP of Taraba State versus Darfur and another, the court held that the right to life is the foundation of the enjoyment of all rights, and that such right to life must be protected by not just the government, but by persons in the society. A gunshot victim has several rights. Number one, he has a right to life, which is a fundamental right that is guaranteed by Section 33 of the Constitution of the Federal Republic of Nigeria. He has a right to the dignity of person. Dignity of person in the sense that he must not be maltreated, must be given the best of treatment, must not be tortured, and must be treated in a humane way, either by the hospital or care center he is, by the security operatives, because if you also look at this compulsory treatment of victims of gunshot act, the law enforcement agencies, the security agencies, and agents under Section 2 are under the legal obligation to assist and render necessary help, even in the course of their investigation of gunshot victims and reports about them. And they also have the right to be informed of the treatment that they are being given. The rights of patients are contained in a policy document called the Patient's Bill of Rights, which is operative in Nigeria. And it also includes such rights as the healthcare facilitator informing the patient the medical procedure and the drugs, etc., that will be given to the patient, informing the patient's relations, the right to information. The patient's relations should also be informed of their whereabouts. If you look at Article Section 10 of the Act that we are examining, and then we read down to Section 15, the medical personnel should not just inform the law enforcement agent, which is provided for in Section 3. Section 10, you read down to 15, also facilitates the fact that the medical personnel should inform the patient's relatives, because it's not just treating the initial treatment. Issues such as further treatment, which will require finances, and then of course the emotional and mental care of the patient with love by the loved ones, is something that the patient should also has a right to be given. And let me also say that the patient has the right to be treated as an innocent person.
Associate Prof.
Freedom from discrimination, and then treated as an innocent person. Section 36 of the Constitution of the Federal Republic of Nigeria clearly states that even when you are charging somebody to court, or the person has been charged to court, such a person must be presumed innocent. A gunshot wound may erroneously raise the impression that the person may be an armed robber or maybe a cultist. Therefore,
let me cut you in. Your great mention of, the police informing the family members and
the health person.
Some of the arguments posed by the healthcare practitioner is that sometimes these people are not willing to talk, are not willing to give out information. What should they do? Or have the law provided any rules regarding that?
We understand the very revered position that doctors and nurses occupy, even in our existence as human beings, no matter the degree you have. If you notice, when Dr. Timothy came in, I gave him a very wide smile because he happened to be my doctor about 10 years ago. And I was just telling him that I really appreciate how you treated me and you and your wife. I benefited a whole lot from there. Luckily, I don't have that issue anymore. We don't expect medical doctors and nurses to be carrying out investigative duty. That's why the Act on Compulsory Treatment of Gunshot Victims clearly states in Section 3 that healthcare personnel should inform the law enforcement agents and let them take out the work of investigation and carry out other forensic analysis on the patient while the medical personnel carry out their medical duties on keeping the patient alive. It's an intricate circle, but luckily for us, the IG came up just last week and said every law enforcement agent, every healthcare personnel or organization must treat these victims because it could be you and I. I mean, I've been on a journey from worry, and then I've had shots at the car I was in. It could be anybody. So I think that the doctors should do their work. Even we, the members of the society, and that's why we commend you. I commend Professor Moji Shola is saying for this very laudable program of enlightening the public, particularly on this topic too. I commend you too. The more work, we all have work to do. The bystander, the neighbor, if you see a victim of gunshot wounds, help. Take the person to the nearest place of help and then let the other stakeholders execute their duty.
Thank you so very much, Associate Prof. Idorenyin. And indeed, this is the initiative of the D. She's using this as a means to intervene legally in this system or in this part of the world. Let me go back to Dr. Timothy Nottidge. When the IGP had made that directive, he was re-echoing the act that had already been signed. And then he said all hospitals, I don't know, before now, is it that private hospitals or government hospitals they don't attend to, or are they specialized hospitals to attend to victims? And then regarding Section 20, which says that emergencies should be treated.
Thank you so much. I first want to thank Mrs. Professor Oyo for those very kind words, and also echo what she said about appreciating the Days initiative in making this happen, because public enlightenment and structured informative enlightenment is very important in any society, even for its survival. And having said that, in relation to your question, it's important to lay the groundwork that severely injured patients must be taken to facilities appropriately staffed and equipped to treat their injuries as best as can be done as soon as possible. Because we have an 8-hour window after which the injury effect on the body can cause more and more damage to the body, which is more difficult to remediate. So we call that the golden hour, so to speak. Now, it's therefore inimical to the patient's best interest to delay adequate treatment by taking to the person to inadequately staffed or equipped facilities. And I say this to cut across board of all severely injured patients, because we regard gunshot injuries as severe injury until otherwise determined, because they can sometimes look deceptively trivial. As a case in point, decades ago now, I had a 32 or so year old man shot when he entered a company somewhere in Oyo State, in his neck on the left side. It was a tiny opening about 2 centimeters. He was more concerned with the problem he had with people in that company than about the injury. To cut a long story short, the bullet was found in his pelvis, in front of his pelvis. I don't know if we know what that area is. It's the major bone of what we call maybe the waist or the hips. And it was found there, having passed from the neck, through the chest, through the tummy, to the pelvis. He was a dead man walking. A lot of preemptive care kept him alive. That's the kind of danger with a law that says take any patient with a gunshot injury any place. It's never done in a structured system that you take an injured patient any place. Rather, the people that do the taking are trained to know, they are called paramedics, they are trained to know which system is likely to fit this patient so he can be saved and helped. Can I please put it to my learned colleagues that this law is a law that will kill many people? Based on the explanation I've given, it's not done in a structured system. To use fiat to provide care where the care may not even be appropriate to the patient's injury is not done.
Doctor,
Therefore, if I can quickly just add, one very important deficit I see is the lack of data in this our system, without which such a fiat experience would never result in good. It will rather result in harm. It's predictable.
Dr. Nottidge, some health practitioners have said that this directive is like a bully. You're forcing them to do what is not right in practice.
Yes. Interestingly enough, the old law that was passed without, as a knee-jerk reaction, as Professor Uyo explained to us earlier, because of the high spate of armed robbery-related gunshot injuries in maybe the 80s, was also not proper because it was hindering patient care. Now, rather than just remove that law and let facilities care for patients as they are equipped to do, another law was passed that was for some reason linked to the right to life, that now puts patients at risk of harm because of improper attention to care. Not because people may not even know what to do, but because facilities and equipment vary in every country of the world. So, for example, in the United States, they have what they call level 1, level 2, and level 3 trauma centers, with level 1 having the most, let us say, the best equipped trauma centers.
So Doctor, you're saying that
if I could just quickly comment that, well, I am of the opinion that the act sought to correct negative situations and save life. I understand what Dr. Nottidge is talking about. He's talking about just taking any patient, the gunshot victim, to any hospital. But doctors and nurses have been trained. If somebody brings a gunshot victim to your hospital and you don't have the appropriate medical facilities, you should give the person first aid or palliative care and transfer the patient immediately to a better hospital that can take care of that victim at that particular point in time. Why the law may not be able to state the best of facilities to take patients to, where bystanders, where good Samaritans input, where police officers or anybody who wants to help rushes a gunshot victim to such a hospital, it could be a medical center, you, the doctor or the medical personnel on duty, give what the layman may call the necessary first aid treatment and transfer the person immediately to where he or she could have such consultants. Such revered consultants as Dr. Nottidge.
Especially providing. But let me be done with Dr. Nottidge. You've mentioned the first trauma, second, and the rest. Does it mean that accidents are being classified and then the facilities which need to be attended to them are different?
Thank you very much, moderator, for that intuitive comment. You've got the point exactly. We stratify injuries. One example, one tool that we use is called the Injury Severity Score, the Revised Trauma Score, the Kampala Trauma Score, which is more useful for us in the developing world, because injuries are of various severities, and the severity of the injury determines what would be, as my associate prof called it, appropriate first aid. But rather than go into those complexities, let me give an example. A patient with a gunshot injury can have a damage to his spleen, which is an organ on the left side of the abdomen. In that kind of situation, typically the spleen needs to be removed. And that removal of the spleen is a major surgical procedure that is regarded as part of the, let me use your term, but we don't use that term, but just make it easy to understand, part of the first aid. So any time in any hospital where anything but that chronic injury is done is killing the patient. And in our setting, we have traffic problems. So in my study in teaching hospital with the trauma registry, we found a lot of our patients coming to hospital with these tricycles we call keke. About a third of our patients came with keke. That's a high number, showing that it's a totally unstructured system. So that this patient had, from the injury site, had to enter, call it traffic, and go to the hospital, wherever the hospital is, then enter traffic again and go to the maybe better hospital. The patient is on his way to the mortuary. So a system that rather than guide us to properly structure the system is fiating us, pardon my French, to send patients into this kind of gloom is actually harmful to patients. My specialty is trauma patient care advocacy. I feel quite strongly about what is in the best interest of victims of trauma because, like I informed one of our former state governors when I had the opportunity, they did not leave their house planning for that, and society should provide for them. This law is against that provision. It's not in their best interest. And that is the fact.
That's so sad. You know, the follow-up question to that, do you think, or what are the challenges that have led to non-compliance of this law among the medical practitioners?
Interestingly, like I said about our teaching hospital here at UUYO, we have always put patient care first. As far as I know, since I came here about 20 years ago, no, about 18 or 19 years ago, we have treated gunshot injury victims as patients with injuries who need care. We have never put, well, since I came, that I know of, put any kind of protocol ahead of taking care of the person wielding with injury. A gunshot, victim of rape, victim of road traffic accident with multiple fractures, head injured patient who is unconscious, doesn't know anybody, doesn't know his name, doesn't know his relatives. We've always treated them as patients who need care and done our best to, and by God's grace, save most of them. So with that background from where I work at teaching hospital, it's hard for me not to say we have treated patients without regard in the first case to being told to wait for a police report, or in the second case to being told to do it mandatorily. We've always been doing it.
But doctor, some people have argued, or some health practitioners have argued, that there are some challenges like funds, facilities, and police report. Sometimes there's this fear that if they treat this patient, because of the lack of information about this law, that the police will come and arrest them, detain them, and even close them the hospital. What do you have to say about that?
Because of that aspect, I like that the law prevents that from happening, and that the Inspector General of Police himself, having echoed the law as you rightly put it, as I understand, means that there will be no problem with treating patients without a police report, whatever their injuries are. Yes, indeed, because we have already discussed stratifying healthcare facilities in terms of trauma. It may not apply for people who need to be delivered for pregnancy or other things or have malaria, but for trauma we stratify them. Because of that, there is definitely a problem with adequate staffing and facilities in terms of treating gunshot injury victims who are presumed to have severe injury until otherwise determined. That's like a very obvious problem with our system. Therefore, this kind of program can help to advise the lay public, because they are mostly the ones bringing patients to hospital up till today as I speak. We don't yet have an ambulance system in Nigeria that I know of. I know 6 states have just started trying to do a pilot project. I don't know, have their names offhand, but I know it's not yet here in Akwa Ibom State. So the lay public should please know, take gunshot injury victims to more advanced centers. Let me please just note, just as a background, that the level 1, level 2, and level 3 system in the US may not fit any of our hospitals in Nigeria at present. I don't know any hospital that qualifies for a level 1 trauma center in Nigeria at present. So we are still that far away from having what it takes to treat this kind of patients. How much more sending them into the society to some hospitals that are run even by people who are not doctors.
Thank you so very much, Dr. Nottidge. Associate Professor Idorenyin, it's a known fact, according to Section 20, which of the National Health Act. Yes, that it is important, you treat emergency victims. But there are challenges. But the underlying fact is that there is right to life. So what are those? Are there any regulatory enforcement agencies, to enforce the things? Or are there any sanctions against health practitioners who go against this? And can the victims sue the hospital or the health practitioner?
Well, I hold the belief, and rightly so, that Nigeria is not in need of laws, but the implementation of these laws. If you look at Section 11 of the Act, the Section 11 of the Act on compulsory treatment of victims of gunshots has clearly stated that any police officer, any hospital, any healthcare organization that fails to treat patients with these wounds and then safeguard their lives first, that if they fail to do that, they're liable to two things: payment of 500,000 naira fine or imprisonment for 5 years, or both. But the issue is, what is the government doing? We don't have enough hospitals. And even the hospitals we have are very much below the standard of international best practices of rendering healthcare.
Associate Prof, whereas you've mentioned governments, let me ask this question.
Okay.
Because some of them believe that when they treat these gunshot victims, at the end, they don't pay. And who bears the cost? These health practitioners, they are people. They're human beings. They feel they buy in the market. Well, who pays them?
Well, Section 10 of the Act that we're analyzing clearly states that a patient, once a gunshot victim has been brought to a healthcare provider, that healthcare provider has the duty to inform his family members within 24 hours. His or her family members within 24 hours of the presence of such a person in his or her health facility. So when you inform the family members, suddenly people will come and aid. That's why the law doesn't expect you to ask for initial deposits first. And we also want to reiterate something. Payment of gunshot victims payment of their medical bills shouldn't be the front burner. That's exactly what the Act is trying to circumvent. On the part of government, yes, we have the NHIS, etc. But how many Nigerians are buoyant enough to even fund the NHIS scheme? How many of them are working in the public sector or in private sectors that can fund the schemes? That is why I am personally calling on government to do what happens in every other developed country of the world. We are developing. Have what we may call the accessible and affordable healthcare scheme, where the woman in the market, the woman in the farm can approach a healthcare provider and get the best of medical services. Nigeria is an all-rich country, so we shouldn't even be talking about where the funds should come from. And I will also emphasize the training of law enforcement agents. If you're investigating, you're not just investigating how the person had to help in investigating to get loved ones of the person, next of kin, enlighten the public, make some declarations on your media or whatever means of communication to let the public know we've been notified about a patient lying in a certain hospital. And I also want to say that the government can also fund hospitals across board, across the nation. Some trust fund can be set up as is set up in other countries, so that when such victims go to a hospital, the hospital will know that there's a trust fund set up, or a providence, or a fund, by whatever name you want to give it, so that where the healthcare provider does not have access to the direct relations or friends of the victim, they can make some claims on an external fund and be able to offset some of their bills. And then the issue of education and enlightenment. That was why I said that I appreciate the person that Professor Modishola is saying, and the Faculty of Law, for this very laudable project. A lot of people don't even know that this law exists. So the public enlightenment could also create a new, some palliative way of making gunshot victims have that right to life, which the law has clearly emphasized. Like I talked about the case of COP of Taraba State and others versus that one another, where the court said right to life is the fulcrum of every other right. And this happens in Western countries. Why can't it happen here? But I still emphasize, the government has to do a whole lot more. You talked about governmental institutions, governmental parastatals. There is need for not just governmental parastatals to execute their duties, but to lean more on helping humanity in the execution of their duties, including in such circumstances.
Associate Professor, let's just hold on. Let me get to Dr. Timothy Nottidge. Dr. Nottidge, you have anything to add to who bears the cost?
Yeah, thank you very much, Margarita, for this question. I did a study on gunshot injury victims that presented to a teaching hospital some years ago, and noted that about 90% of the victims were from the low socioeconomic group. So that settles the situation about payment with respect to the patient or their relatives. They won't have the funds to pay. I saw patients this morning at teaching hospital, 1, 2, 3. I think all the patients that were in the emergency room that I saw that were referred to me did not have funds to pay for their care. And a lot of things that they needed are delayed because of funds, etc., etc. So Nigeria is meant to be the largest economy in Africa. I don't know if that still holds. We're now behind South Africa, but practically we function like a low socio-economic country, which means that if you make a law that provides for a requirement without the means to sustain it, the law becomes unenforceable, may not be the word, may be difficult to apply to the reality on ground. Decades ago, one of my teachers told me, because he trained in the UK, that when they find such a situation in the UK, because when you can't implement a law practically without arresting half the people affected, then that law gives room for corruption. They would immediately withdraw that law. I think this law is long overdue to be withdrawn and properly worded to ensure that what comes out will provide actual required care for the patient, means of that care in a sustainable way. Because as we speak, if people come to the hospital and 90% of them with gunshot wounds don't have the money, how do you want private hospitals that also fund what they do from their pocket, so to speak, be able to care for such patients in a safe way without compromising on the quality of care? Because it's one thing to deliver somebody somewhere and require that something that the IGP has said must be done. Another thing to provide quality of care and not find a way to survive as a small facility without getting crippled by cases like this, especially in states that have a high load of them that we don't have in Acquired State, as far as I know.
So I think because of time, just in 45 seconds, what's your advice? What's the best way for effective implementation?
Yes, I think there is a need for data to be obtained on this matter in terms of what are the means people have to care for health in the first place. To leverage on the South African model, which actually provides governmental funds for people who do not have a means of their own survival. And then, with that reality, rephrase the law so that it can be implemented in a way that will be in the best interest of patients, as this one clearly is not.
Thank you so much, Dr. Nottidge. Associate Professor Idorenyin, the last question for the role is, just like I asked him, what are your advice? So what advice would you give? And then a lot of people have said that this law is so porous, the act is so porous, that it has not really covered a lot of aspects of this medical practitioners, because a victim could be brought and then it might be a victim as a result of cold clash. And if this victim is not treated, the medical practitioner now might be in harm because they might beat him up. So what is this law doing, or what would be your advice, to cover up all these loopholes in this act?
Well, the truth is that no law is perfect. That's why you have amendments of laws. We've discovered some flaws as per funding of hospitals and healthcare facilities. By the way, I just want to emphasize that the law is still in existence. An article and section 1 of that act clearly states any hospital, whether it is public or it is private, must render the necessary health care to victims of gunshot wounds. So I know there are impediments to this, but I just needed to emphasize that because, the case of Idorenyin Jones and several other cases where people are begging medical personnel, please just attend. Please just stop the man from dying. It could be anybody lying on the ground. So I really want to emphasize the fact that please, our medical doctors, our medical personnel, we appreciate you so much. Tend to the patients when they come and do the best you can to save that life. If it's a cultist or it's an armed robber or whoever it is, the law will take its course. And on the part of government, the politicians are taking millions of naira off to their personal coffers under whatever nomenclature they give it. There is a need to provide adequate funding for our healthcare facilities, whether public or private. Train our medical personnel, give them what we may call booster funds, so that when relations of patients can't pay, they can draw from these funds and then inject money into public enlightenment programs. Because it's not just enough to train the healthcare personnel and provide funds. Let people know that these laws exist. And then I also want to emphasize, in the United States, we have what we popularly call the Obamacare. In the United Kingdom, we have the NHS. Let's have a workable healthcare system, trust fund scheme, whatever name we may call it,
Sure.
where the poorest of Nigeria or any resident in Nigeria can access healthcare, not just in gunshot incidents, but in all other incidents, because life is wealth. Thank you.
Thank you so much, Associate Professor Idorenyin. Indeed, life is wealth. Thank you so very much, Associate Professor Idorenyin. Yes, she's the Associate Professor of Law. She's an attorney and also Head of Department Public Law. And thank you so much, Dr. Nottidge, who is also an Associate Professor and Honorable Chief Consultant in Orthopaedics and Traumatology. This is why we call it a wrap on today's edition of Jurisprudential Tuesday. I hope you've learned, because I have learned. This program is brought to you by the Faculty of Law, and special thanks to Bixie Benson, Emmanuel Richard, the faculty media team, and the executive producer of this program, our digital dean, Professor Wojisola Esenyi. And I have been your favorite host, Odinaka Chiku Ihanacho. Till when next we come your way, make sure everything you do remains legal. We're saying bye-bye.